Carmelo Anthony is not going quietly into his 35-year prison sentence for murder.
He put his hands on me. I told him not.
Carmelo Anthony is not going quietly into his 35-year prison sentence for murder.
He put his hands on me. I told him not to. He put his hands on me.
Now, a powerhouse defense team is fighting to undo the verdict that branded Carmelo Anthony a killer. What started as a track meet confrontation ended with a fatal stab wound and a murder conviction.
I know how I go. I'm not alleged. Okay.
The case appears closed, but Anthony's new defense team is preparing a challenge that could put the entire verdict back under the microscope. We're on the case presented by Law and Crime. I'm Chris Stewart. Right now, Carmelo Anthony is currently living in a rural Texas medium security prison. It's about 3.5 hours south of Frisco, Texas. That is where Anthony used to live. It is where Anthony stabbed Austin Metcalf in the chest at a track meet, and it was a wound that killed Austin Metcalf. And of course, this all happened, and we've talked about this story a lot, after Carmelo Anthony ended up under the tent of Metcalf's team at this track meet, and he wouldn't leave. The state said that Metcalf then confronted Carmelo Anthony, that he shoved Carmelo Anthony, and Anthony responded with a knife that was in his backpack, striking Austin Metcalf and giving him an injury that the medical examiner says there is no way that Austin Metcalf would have survived. And the jury, it only took them 3 hours to determine Carmelo Anthony's fate, and it was that he was guilty of murder. But now, Carmelo Anthony has a high-profile team of lawyers who are preparing to challenge that verdict. We received an email from the Stand with Carmelo Coalition, and this email announced 6 lawyers will conduct a fresh, independent review of the trial record. It goes on to say, quote, "We recognize the profound loss suffered by one young man's family and the uncertainty facing another, and we extend our respect to everyone whose lives have been forever changed by these events." So this team of lawyers, they will be serving pro bono, according to the email. Now, we're going to go through what makes this team so high profile and potentially high powered in just a moment. But first, I do want to go through some of these new images that we have in this case.
I know how I go. I'm not alleged. Okay.
This is body cam video from one of the first officers to confront Carmelo Anthony after he stabbed Austin Metcalf at this track meet. This body cam captures the moment that Anthony made this now infamous statement, quote, "I'm not alleged, I did it." And you heard it clear as day on that body cam. Now, the court has released a large amount of evidence that was shown to jurors during the trial, including body cam footage and surveillance video. Now, because cameras were not allowed inside the courtroom, the public is now only getting to see what the jury saw. Now, here is the only known video of the moment where Anthony stabs Austin Metcalf under the tent. And it's from a camera that was mounted on top of the football stadium where this track meet was going on in April of 2025. Now, the state argued that Carmelo had no reason to be under Austin's team's tent. Now, the defense argued that Carmelo knew someone there and he was welcomed under the tent. But what happens next is Austin Metcalf reportedly tells Carmelo Anthony to leave, and when Anthony didn't, words were exchanged, and Metcalf puts his hands on Carmelo and shoves him. And you can see, it's very blurry, but you can see that shove in the surveillance video. Now, that shove was met with a stabbing from Carmelo Anthony. He pulled a knife out from his backpack and stabbed Anthony in the chest. And again, it was a wound so severe, a stab wound to the heart, that the medical examiner said there is no way Austin Metcalf could have survived. In fact, the medical examiner said if there was an operating table right there with a surgeon, it is not likely that Austin Metcalf would have survived that injury. He died on the track. Carmelo, he ditched the knife and he ran. His defense argued it was because he was afraid for himself. He was just trying to get away from the situation. Now, here is more body cam video of what happened next when officers confronted him on the track.
So nothing on your person at all? No, nothing? No, mind if I reach in your pockets and stuff and all that? Stab me? Okay. I'm okay. Little personal there, okay? Just to make sure.
My car's right there.
Okay. Yeah. All right. The victim's going to be underneath that tent over there, so I'll get medics.
Thanks for analyzing.
Memorial tent over there, guys. All right.
He put his hands on me. I told him not to. He put his hands on me.
What's happening right now? Victim, we'll be on the north end. They got staff standing to him right now. This is the late suspect. Okay. Already? No. We searched them. Got nothing.
I don't know what happened.
413. Check everything about CPR process for a little bit.
Crazy.
You can have nothing.
Crazy.
Oh, my side, okay, what's that? It's up to you. It's up to you.
That's fine. This is closer.
Okay. Let me do one more little check of you, okay?
Yes,
You don't mind for reaching your pockets, anything like that? You good?
You're wearing this one pair, man?
I'm wearing some little underwear.
Oh, yeah. But did it come back in?
No, ma'am, I don't think so.
Okay.
Right. What's your name, man?
Carmelo Anthony, KARMELO.
Okay.
Crazy.
Have a seat here real quick, man. Watch your head. Let me check your hood here, buddy, okay?
Yes, sir.
Well, I'll tell you what, lean this way so you're not resting on your hands, okay?
Yes, sir.
All right, see a little bit of blood on your hands there, okay? All right.
Follow two, I don't see.
So your first name is Carmelo?
A-R-M-E-L-O.
Let's see, hold on a second.
Is he gonna be okay?
I don't know yet, man. Carmelo, C-A-R-A.
K-A-R.
K-A-R.
M-E-L-O.
M-E-L-O. Carmelo, what's your last name? A-N-T-H.
O-N-Y.
O-N-Y. Where are you going?
I'm in 12th grade.
10th grade? You go to Emerson?
No, sir.
Where'd you go? Centennial. Okay.
I'm in 12th grade.
12th grade? Okay, no, it's 10th. All right, sit tight for me real quick, bud, all right?
Guys, real quick, running a business is tough enough, but why make it harder doing things manually or relying on dozens of apps that don't talk to each other? That is where our sponsor, Odoo, comes in. 9 years. Now, the day after when it came to the testimony, it took the jurors about 3 hours to find him guilty of murder. Then it was another 3 hours that same day, roughly, for them to determine that his punishment would be 35 years in state prison. It could have been as many as 99 years. Now, the day after his sentence, Carmelo Anthony filed a notice of appeal from prison, and he wrote in that notice of appeal that he doesn't have the money for an attorney. But that doesn't appear to be an issue any longer because he has this pro bono team of lawyers now in his corner. So let's go through this team of lawyers. According to the Stand With Carmelo Dallas Appellate Attorney Russell Wilson II, who once led the Dallas County District Attorney's Conviction Integrity Unit, and according to the DA's website, one of that unit's jobs is to send out, quote, mass notifications where systemic errors affected or potentially affected the judicial process. You also have Austin-based attorney Gary Bledsoe, who is the president of the Texas NAACP, and he's been in that position since 2001. And he is, quote, admitted to practice before the U.S. Supreme Court and the Fifth Circuit Court of Appeals. Next, you have Michael Ware, who's a Fort Worth-based attorney and former prosecutor, and he's the executive director of the Innocence Project of Texas. He was inducted into the Texas Criminal Defense Lawyers Hall of Fame last year. With them, civil rights attorney Brooke Clues, who is a former Houston public defender, and she is now chief of staff for high-profile civil rights attorney Ben Crump. And another high-profile lawyer on the team is Sean Daradia, who is based in Dallas, and he's had multiple clients acquitted in high-profile murder cases, and he serves as a TV legal analyst. And finally, you have trial lawyer Justin Moore. He's also based in Dallas, and his description reads, quote, he has represented clients in high-profile criminal and civil rights matters, including securing the acquittal of a teenager charged and falsely accused of capital murder. So it does seem to be a very high-profile team. The question, of course, becomes, what might they actually be able to do to overturn the conviction of Carmelo Anthony, and what happens next? Joining us now to talk more about this from Texas, criminal defense attorney Anthony Asso. Always great to have you on Law and Crime. So if you're a prosecutor on this case, you look at this lineup, how nervous are you that this conviction may actually not stick?
Well, as a prosecutor, hopefully you're not nervous, right? I mean, I think from a prosecutor standpoint, you should be bringing cases to trial that you feel the state has evidence to prove, right? And you've got to trust that your line lawyers, the trial lawyers in that case, did what they were supposed to do, right? Which, in addition to trying to get the verdict they want and the sentence they want, is also making sure the record is clean so that the conviction sticks for decades to come.
And what happens now? I know that Carmelo Anthony filed a notice of appeal, and then we got the update here of who his attorneys are going to be on the appeals process. What do they do next?
Right. So it's just a timeline. You have to file the notice of appeal within a time period. And then from that point, they'll get a scheduling order of when the actual appeal is filed. And that at that point, the court will review it. They'll probably need to get a transcript, a trial record, and the court will have to go through that. And they'll make their decisions regarding the appeals after reviewing the record in both parties' arguments, both the state and the defense's arguments regarding the appeal.
Because post-verdict, we've seen so much debate from people who were just following this case to columnists of all different kinds, legal analysts about the facts of the case and everything that went down in the trial. And then, now the body cam and surveillance video was released in the last couple of days. So people are looking at that too. But in an appeals process, like what will Carmelo Anthony's team actually be looking at to determine whether or not he would get a new trial and whether this conviction could actually be overturned?
So they're going to be looking at the record itself, Chris. This isn't going to be a situation like much of the public is doing, where they're looking at, well, why didn't the defense argue this or why didn't they argue that? What they're going to look at is really errors within the record, both constitutional errors and structural errors. So did the judge allow hearsay in against the defense's objection? Was there a jury charge instruction that was let in that shouldn't have been let in? I think we'll probably see an objection to the judge's ruling on the Batson challenge. The defense did object. They did make a Batson objection, and the judge overruled that objection. So I'm sure we'll see that as being one of the issues that the court rules on, in addition to a number of other issues, probably a sufficiency of the evidence argument, and then various other pieces of evidence that probably came in that the defense will re-urge their objection on the appeal.
Because there have been people who have looked at the jury selection process. We've heard the term Batson challenge over the last couple of days since this verdict came in. For people who are just kind of following along, may not be lawyers, what exactly is a Batson challenge, and what Carmelo Anthony's team would have to prove for that to be successful?
Sure. So in jury selection, you cannot you can't strike somebody on the basis of gender or race. You have to have a gender or race neutral reason for striking that person. So in an instance of a trial, if the prosecution strikes a few, we'll use in this case, for example, they strike a few black jurors, then the defense might think, hey, well, the prosecution struck black jurors because they're black. And so they can make a Batson challenge. The burden then shifts to the state to provide the court with race neutral reasons for having struck black jurors. And so in this case, I think the state argued that they struck these jurors because they were educators of young children or kids. And so they felt that they wouldn't be good jurors in this case because they might be more sympathetic to Mr. Anthony. And the court found that that was a sufficient race-neutral reason and overruled the defense's objection.
When it comes to some of the work that this team of 6 attorneys and again very accomplished lawyers, it seems, when it comes to the work that they're going to do, because in the notice of appeal, Carmelo Anthony, says that he doesn't have any money, which makes sense. He's 18, 19 years old, and he is now an inmate in Texas State Prison, doesn't have a job, career on the outside of it. He had just graduated high school. Like, how does, assuming that this team, for all the prestige they have, they're doing this pro bono, and if it's like the full force of all their law firms looking into this, like, what does that get you in an appeal process as you go through the record compared to some recognition on their case, and they're just kind of going through the appeals process, as I'm sure a lot of people who have been convicted of crimes end up doing?
Well, with a team like this, you should expect they're going to lift up every rug, and they're going to look under every rock and make sure that no stone's unturned. And a lot of what they're doing, because it's a serious hurdle in an appeal, right? Because with these constitutional errors, sure, something might be wrong, but not only does the defense have to prove that something went wrong, a piece of evidence was let in, a juror was allowed to testify regarding certain conduct, an instruction got into the jury charge. They also have to prove that there was harm, that error caused harm, and but for that error, we would have or could have had a different verdict. And so it's a really high burden for a defendant on an appeal, but they're also preserving the appellate record for potential appeals down the line, post-conviction appeals like post-conviction writs of habeas corpus and things of that nature.
Who eventually, because obviously it was a jury of his peers, and I know people have debated the racial makeup. It was majority white, wasn't an all white jury, but a majority white jury that made this decision. The judge stands by the decision. Who, as they prepare the appeal process, like who eventually, or the group of people, are the ones who would determine whether or not this conviction sticks?
Well, it'll be the appellate court justices. And so they'll look back. First, the appellate lawyers for Mr. Anthony are going to have to make the arguments. They're going to have to raise these issues. The issues that they raise are going to have to be issues that were previously raised in trial for the most part, right? And that's why it's so important, like I talked about earlier with the prosecutors and keeping a clean record, it is crucial that the defense attorneys in this case make the objections when necessary, because they know they've got to preserve this record for appeal so that they can give the appellate lawyers the ammunition they need to make the objections to the appellate court. But ultimately, the verdict by the jury as well as the rulings by the court and determine whether this conviction sticks. That is a really, the judge views the trial court's rulings and the jury's verdict in a very deferential matter. So it's really light most favorable to the evidence that was presented at trial.
Because there's been a lot of criticism for just people who've been following along with this trial of the defense of Carmelo Anthony. You're a criminal defense attorney. I'm not. As you know, it is a really hard job and like kind of Monday morning quarterbacking in a situation as serious as this. But there is the decision that was made, and whatever went into that decision, it's kind of unclear of why Carmelo Anthony did not testify in his own defense, since he was really the closest witness to what happened. And if you're alleging that you were afraid for your life and you needed to do this to protect yourself and all of that, I think jurors would have really liked to see that. First off, let's just talk about that decision in and of itself. Like, what did you make of the decision for Carmelo Anthony not to be on the stand?
Well, I agree with you, Chris. I think any juror is going to want to see that. And I'm sure the defense probably went over that issue during jury selection and weeded out or tried to weed out the jurors that would hold that against the defendant if he didn't testify, but people slip through the cracks. And so I think in this day and age, if you're arguing self-defense, people want to hear, well, what made you so scared that you felt the need to use a knife in a fist fight, which it wasn't even really a fist fight according to the testimony we heard. So I think it's that judgment call is something the general public may never have the true insight on, because we weren't with the defense team. You got to assume that they were preparing Mr. Anthony to testify for trial. And if they didn't feel like he would be a good witness, or they felt that he would do himself more harm than he would benefit, then you've got to make a judgment call as a defense attorney. And in certain instances, defendants just don't want to testify. So there's a lot that goes into that decision. But again, I agree with you. I think in this kind of case where the facts aren't necessarily on your side, you have prosecution witnesses talking about provocation, you as a defendant really need to get up on the stand and tell your side of the story.
And I don't know if this is what happened. I don't know if when they went into a back room and they're deciding it, maybe it was Carmelo Anthony who said, I just don't want to do this. I don't think I need to. We're unclear. But when it comes to the appeals process, if the defense team looked at Carmelo and said, you should not testify in your own defense, and maybe that was the wrong decision, like, is that something that could be made into the appeals process, that he just got bad advice in that situation? It was a bad strategic decision and things could have been a lot different had he taken the stand?
So no, Chris, it wouldn't. That would be an ineffective assistance of counsel claim that would likely be brought up during the habeas corpus part of an appeal. But assuming that we were there, that's probably not going to be a winner argument, because the attorney's going to provide an affidavit and state that here was our strategy based on the evidence that we had, the evidence that was in a trial, and our woodshedding in preparation of the defendant. We did not feel that it was the best strategic decision for him to testify. That's different than if the defendant wanted to and they forced him not to, right? Because in the end of the day, the defendant has the absolute right to go to trial. They've got the absolute right to testify in their defense. And so if they didn't provide him that opportunity, then that would be a cognizable claim for an ineffective assistance of counsel argument.
Because I'm sure you go into a prison and you talk to people about how their trials went. A lot of people probably weren't thrilled with their defense with just the outcome of how it went. Like, what is the bar when it comes to ineffective assistance of counsel? Like, what does that actually look like in effective appeals claims?
It's an unfortunately really low bar. I think that there's a case where a defense attorney was asleep during trial and was not found to be ineffective, not found to have provided ineffective assistance of counsel. So, but on the less extreme side of things, as a defense attorney, you've got to make judgment calls based on your experience and based on what's been put into evidence before a jury. And so the courts really do provide a lot of deference to the decisions made by the lawyers. And so it's a really high bar. It's hard to overcome that, which is why it's really important for any appellate lawyer to make sure that there's a distinction in their argument of was he advised not to testify and chose not to, or was he truly not provided the opportunity to testify? And I don't think we have the latter in this instance. I'm pretty sure probably that he was advised not to testify by his lawyers and took their advice.
When it comes to, so 35 years in prison is the full sentence. He'll have to serve 17 and a half.
Yes.
How long does the appeals process, like for this case, like how long are we looking until you kind of see the arguments made and whether there could be a decision on whether or not maybe they find something we don't know, but I guess how long does this appeals process typically take?
The appeals process on a 35-year sentence can take a really long time. Now, there's stages of the appeal process. There's the direct appeal, and then there's the post-conviction appeal. And so the direct appeal is a lot quicker than the post-conviction appeal. When the appellate court affirms the trial court's decision, then the case that's deemed a conviction, and then the defendant, under Texas law, would be entitled to file a post-conviction writ of habeas corpus under 1107. That process takes a lot longer because in that process, it actually allows the parties to investigate and create a record. They can get affidavits from new witnesses. They can get affidavits from witnesses that may have provided the defense evidence that the defense chose not to use in trial. They can get affidavits from the defense attorneys themselves where they're explaining the strategy behind their decisions in trial. And so you build a lot larger record. That investigation takes time. And you can file, in certain instances, you can file more than one writ of habeas corpus. So that can take decades.
So even, I mean, I know, like, let's just say he was out in 17 and a half years. I mean, how likely is it that he's out before his appeal process could even go the full length?
On a case like 17 and a half years is a long time for any case,
right?
Because that 17 and a half years he will do day for day. So it's likely that he will exhaust his appeals before that date comes. Once that date comes, once you're paroled out, then the issue sort of becomes moot. And you don't have, the court no longer has jurisdiction to hear the appeal. So it's a possibility that if the appellate court affirms the decision or the ruling, the jury verdict, and it goes into habeas proceedings, that could take a very long time. So it sort of just depends on a case by case basis.
And what did you make of it? So I think it was between 5 and 99 years he could have received as a sentence. He gets 35. Just knowing criminal defense in Texas, and this was a case where he's in this confrontation. He doesn't have any sort of a previous criminal record. What did you make of the 35 years for Carmelo Anthony?
I think it's a really stiff sentence for a kid that committed a crime at 17. The caveat to that is a 17-year-old lost his life over what the jury's determined to be a really senseless act. And so but that's three and a half decades, Chris. I mean, the kid, it's more than twice the kid's lifetime. And so I think it's a really high verdict. And I'd like to understand more what the defense's sentencing preparation looked like in a case like this.
Because, and that was one thing that stood out to me was, it was 3 hours or so to the guilty verdict. And then I was thinking, as we were kind of waiting for information to come out, it's like, okay, so maybe tomorrow they do the punishment, the punishment part of it, let everybody get a breath, but they go right into the punishment phase for Carmelo Anthony. I mean, it felt like within, the hour, his mom is on the stand pleading for mercy from the jury. And then 3 hours or so after that, they come back with a 35-year number. Is that typical in Texas to kind of go that quickly from verdict to sentence within the day?
It's a possibility. Yeah, it can happen in any district court, and that's really just a judge by judge situation. If I was in the defense's situation, or if I was a judge, I would be inclined to probably break for the day and have the parties come back for sentencing the next day to give the defense time to regroup. That being said, you're using jurors' time. People have just spent a number of days listening to pretty gruesome evidence, and they're away from their families, they're away from their work, and judges have the responsibility of getting cases to verdict expediently while preserving the rights of the defendant as well as the state's rights in these cases. So you do see courts jump right in from guilt, innocence, and punishment. And as a defense attorney, you have to be ready for the bad news and the one-word verdict, and turn right around, put your game face on, and argue why the jury shouldn't sentence your client to a term of a large number like 35 years.
Yeah, I mean, again, mid-50s. You think the kid, he's 17, he just graduated high school, mid-50s on the way out. But then, for the Metcalf family, Austin's never coming home. Very, very sad case in Texas. You wonder,
and I've seen this in jury verdicts, right, where a jury will send a meeting behind their verdict, right? And so they can't really consider parole, but they were probably made aware that parole, that the defendant would have to do half the time before he was eligible. And so you wonder if they took that into consideration and saying, well, make him do 35, he'll do his lifetime, he'll do the victim's lifetime. Just something that kind of crossed my mind as we're talking about numbers.
Yeah, no. That's a good point. I hadn't thought about that yet. And we'll see what happens. This appeal process, certainly a high-powered team, but what impact will it make in the long run? We'll see. Anthony Asso, criminal defense attorney out of Houston, Texas. Thank you for taking the time to be with us here on Law and Crime. It's great to be with you.
Chris, always a pleasure. Thanks.
That will do it for On the Case, presented by Law and Crime. Subscribe to us streaming on Peacock. I'm Chris Stewart. We'll see you next time.
Okay.
Okay.
Okay. What's your name?
Nathan Nordyke.
What's your last name? Nathan.
Yes, ma'am.
What's your last name?
Nordyke.
Okay. And do you see any of the responders there yet?
We hear the sirens, but
Okay.
the coach has sent us out. We're all walking to our buses.
Okay. So you're going to get on a bus right now? Okay. And the rest of the students are walking towards the buses?
Yeah, everyone's being evacuated out the stadium.
Okay.
Thank you so much for being quick.
Okay. Just follow whatever directions you're being provided by either the officers or by your coaches, okay?
Yes, ma'am.
Okay. I'm going to go ahead and disconnect if you need to, but we've got all kinds of help headed that way.
All right. Thank you.
Thank you. Bye-bye.
Bye.
What's up, family? If it's your first time checking out the show, let me know what city, what state you're coming in from. If you're outside of the U.S., let me know what country you're representing. Throw up your flag. Family, I need you to smash up the likes, smash up the likes, smash up the likes. Family, I got a special guest in the studio all the way from Dallas, checking in to help us navigate through this wild, crazy case. I got a trial attorney, Andrew Wilkerson, in the building. Boom, there he is. That's a good.
What's
man.
going on, man?
Hey, thanks for coming on the show. I'm good, man. I'm good, man. Just trying to process this case just like everybody else. This is what one might call a juggernaut, right?
Yep.
Yeah. So now that you've had a chance to see the incident video, now that the arrest footage has been released, you've heard the 911 call. If you had been the lead counsel on this case, what would you have done differently than either side?
I wasn't there, right? So I didn't see the trial, but I'm sure that I've heard everything that y'all heard and seen everything that y'all seen, okay? But I'm sure by now everyone has heard that he did not testify, okay? It can't be too many reasons for that. It's either because they weren't prepared for him to testify, which falls on his attorney, or they thought that there was some bad evidence, that was gonna get presented if he testified. So I'm saying all that to say is I would have had Mr. Anthony ready to testify. I would have had, because it seems that, in going through the police report, there's many things that needed to be further explained. The fact how he says, I think it's on page 2, man. He says, I'm not alleged, I did it. He put his hands on me. I was protecting myself. You got to understand, in a place like Collin County, there's a cultural disconnect, okay? He's a black man, he's a black boy. Our culture is different from theirs. They don't really understand how we talk, how we walk. You see what I'm saying? And I don't know how white folks took that. Touch me and see what happens. Well,
they took it as a threat. They said that was a threat. They said that goes towards intention. Premeditated is what some people use. The word that some people use. Do you think that if let's say he did say that, does that create a premeditation argument?
No. If he said that, I would face it right in front of the jury and ask him what he meant by it. And that's the problem. You see what I'm saying, Willie? He didn't even take the stand. So he wasn't able to get up there and say, I wasn't threatening him. I was telling him that if he did something, I was going to protect myself to the fullest of my capabilities. That's all the jury needs to hear him say, instead of letting the jury sit here and go back and discuss what they thought he meant. You understand what I'm saying? And understand, those are just collateral issues. The main issue we needed to test about was the self-defense issue that they tried to get. And, to be quite honest, I was talking to my highly esteemed colleague, Michael Campbell, about this. Even in order to get manslaughter, he probably needed to testify, right? Because for self-defense, you need to testify that you were afraid of serious bodily injury or death. But for manslaughter, you need to tell them you did it because you were angry. Right? The jury was not let into the mind of KARMELO Anthony, period. And that was so that's my answer to that question. I would have had him ready for all of that.
What do you think the chances are that KARMELO Anthony's defense attorneys purposely sold him out?
Look, man, I usually don't get in other attorneys' business. I say that a lot because it's true. But in looking at what happened, I don't know if he did it on purpose. I don't know if he did it on accident, but it's the same result. Either you one of the good old boys, right, which is bad, or you just so incompetent that you didn't know how to prepare yourself correctly for this trial. And that's bad. So I don't know if he did it on purpose. All I know is I see the result and I heard what occurred. And back to your last question too. Even Willie, you can't say hit me and see what happens and I punch you in the face. And I'm right for that. That's assault. You see what I'm saying? So I just want to take it back because people got it wrong. That's a collateral issue. That don't matter if he said, touch me and I'll do something. It don't matter because I can't be on the street, right? Downtown Dallas or downtown Houston, and somebody say something to me and I just punch him in the face. I'm still going to jail for assault. I'm still the aggressor. Not adequate provocation. I just wanted to, go back on that.
Another thing is this, man. I hear the police saying all the time, don't move, I'll shoot.
Come on now.
They move and they shoot. And
they claim self-defense.
Show me your hands. Don't dig in your pockets. Don't do it. I'm gonna shoot you. I'll shoot you. I'll blow you. I've heard him say, "I'll blow your motherfucking head off if you do that." You do that. Pow. That's what happened. Is it Sandra Massey?
Yep. And next thing you know, they're saying the magic words. I was in imminent fear. Who says imminent fear? That's coach. The regular person don't talk like that.
Somebody that's coached.
Right. Exactly.
Yeah, Andrew. What do you think it was the single most powerful bit of evidence on both sides?
I think the fact that on the state, let's start with the state side. I think the fact that they were allowed for 21, I think it was 21 witnesses to get up there and all of them to, render an opinion on the ultimate issue. I heard that the last question for all, because I do this. So I heard that the last question for all 21 witnesses was, do you think this was self-defense? Well, I'm hoping Mike Howard objected because they shouldn't be saying if it's self-defense in front of the jury, because that is a question that causes for them to make a legal conclusion and they're not lawyers. So if he objected, that's something that they could take up on appeal. If not, the state might have snuck that one by. But, to sneak something by somebody 21 times, again, that either speaks to his incompetence or his involvement. I don't know. I ain't saying which one it is. You see what I'm saying? Go ahead.
I think it's both.
It could be both.
The reason why I say it's both is because, number one, it was just for him not to present that, for him not to object, but only like a one or two times during the entire trial, for him to think he could get away with that. That shows the incompetence. Like, I don't care how smart you think you are. You got to be short bus, window licking slow to think that you're going to be able to present that case in front of the world and that people ain't going to see what happened and call that out. And that's why I do believe, that's one of the reasons why I do believe to assemble such a great appellate team of lawyers. Because those lawyers looked at that and was like, nah, man, that ain't right. These lawyers got reputations, just like everybody else. And they got integrity like everybody else. So they like, man, they're not just going to put their career on the line for somebody who don't think that they can adequately defend. I think that the reason why those lawyers got on board is because they see this case and they see how unfair it was. And I'll just go straight. I'll call it striking a ball a ball. I think what those lawyers did was absolutely criminal. And they should be investigated. Also, those 21 witnesses need to be investigated because I'm sure that some of them perjured themselves. The Eddie guy, are you familiar with him?
The guy that said he didn't know him, is that him?
Yeah, the guy who was identified as Carmelo's friend, but Carmelo's girlfriend's cousin in some type of loose relationship as a cousin, right? This guy is the one who called Carmelo over to the tent and told invited him to sit down. He allegedly recorded it. And when the trial happens, he gets on the stand and say, Carmelo wasn't invited. He don't even know who Carmelo was. And they got pictures of him with Carmelo. And he said he didn't even know who Carmelo was. This guy is very sketchy to me. This guy needs to be investigated. This Eddie guy is a primary example of how important it is to pick your friends carefully.
I mean, look, I can tell you for certain that Collin County will coach their witnesses. 2 months prior to this, we got a not guilty out there in Collin County on the murder case. I think it's out of the 290-something court. But we got, 2 months prior to this. And what you have to do is, that's what I'm saying, Willie. I wasn't there. So I don't know the veracity or the tenacity of this man's cross-examination. I don't know if he was letting them slide on certain things or if he was going at their throat. But, the reason, you don't let nobody go till you finish with them on that stand. I ain't letting you go till I'm finished with you. I'm going to have a detective up there all morning. If you got to use the bathroom, you might well go and use the bathroom, come on back, because we're going to be here for a while until I cover all these questions I prepared. You see? So all you got to do, if you prepared your cross-examinations for all 21 witnesses, you've seen what they said before, them saying something different from what's in their statement, that ain't no excuse. Oh, that's a dream. Oh, I love for me to review all of your statements that you gave, and you come here and say some more shit. Please do that, because I'm going to rip you off the bone. So it's just really no excuse for it. And this perjury thing, man, in that murder trial, I told you that I won 2 months prior to that. All white jury, by the way. I got a witness to say that she was lying 3 questions in.
Now, what was the complexion of the participant?
Of the defendant or the witness?
The defendant and the victim.
Black. Both of them were black.
Okay.
Both of them were black. So, you know, the prosecutor stands up and says, Judge, I'm sorry, I told her if she tells the truth, she'll be fine. And I'm looking like, well, nigga, she ain't tell the truth. She just told the jury she lied. But my point to you is, perjury is when you're charged for lying under oath, right? Mr. Willie D, who's going to charge him? You see what I'm saying? You think the DA about to charge their own witness with perjury after saying what they told? That's the issue with perjury. Perjury is a fallacy. Perjury is for who a witness, and you go say what the DA told you to say in this front little room. You see what I'm saying? He's not going to charge you with perjury. Only way he's going to charge you with perjury is if you go off the island, if you go off the reservation and say something different. That hurts his case. But he's not finna, you know. So that's a dream. All that perjury talk. You got to know how to control your witness. You got to know what's in your evidence, and you got to prep your cross. Your cross might go left. It's going to be a fork in the road every 5 minutes with your cross. But you're supposed to be prepared for that. So, you know, like I say, it's just I can't think of an excuse, man.
Do you think that Jeff Metcalf, Austin's father, is helping his, I would say, his reputation, his public reputation by going on these interviews and speaking? Is he helping or hurting his public opinion about him?
Is Jeff Metcalf hurting Jeff Metcalf?
Is he hurting himself, and is he hurting the case going forward? Because this ain't over. Carmelo is appealing this decision by the court, and so this is not over. And what I want to know is, have you seen the racist rant that the dad went on?
Man, I think I saw the first two, and then I just ignored them, man. But to answer your question, I think he's hurting his own image. I think that he's a very outlandish and proud person. I don't know what reason he got to be proud, but he acts very proud. He talks too much. He says racial things. You know, I think he's a bad winner. I think he thinks that this is over and he's won. I think he's a bad winner. He one of them folk. You know, after they beat you, they just got to shit talk you. You see what I'm saying? I mean, I think that his comments are reflective of where he sits, though, in the racial argument. You know, I think they're very reflective of what side he's sitting on. I think it helps Carmelo's case. And you mentioned it, the team of attorneys he had. Man, Russell Wilson leading that thing, man. That's a bad boy. Russell Wilson, I hired Russell Wilson for me. Whenever I got here to contempt, he came and handled my business. So that's what I'm talking about. A brain, man. A brain. Like he gonna outsmart them folk over there. He gonna come at them in all different directions, and he gonna outsmart them folk, and he gonna do it in a very meek, astute, and just, you know, calm. But he gonna be at their throat though. And then you got Justin Moore. You know, he's a civil rights attorney. I know Justin Moore got a couple murders under his belt. And another thing about Russell, he tries cases and he does appeals. So you're not going to get too much past Russell. Like, Russell knows how to look at that transcript for the trial and point out what's wrong and fix it. You know what I'm saying? So, you know, I got a lot of faith in that team, and I'm very excited, man. I'm very excited about that.
Mm-hmm. Well, was this case more about the law, the facts, or the credibility of the witnesses?
I think it was more about the law. Well, if the appeal, let's speak positively. When the appeal is granted, it'll be about the law. I think right now the case is about the facts. I think that's why they got the result that they got, because they leaned too heavily in the facts and they didn't use as much of the law to their advantage. And, you know, you can't use the benefits of a self-defense claim without the defendant letting the jury inside his head, man. You just can't do that. It was almost like a pump fake or something, like a 3-day long pump fake. I mean, you set it up for him to testify, and then he don't testify, And it's only two reasons. Either you didn't prep him or he was scared shitless. But proper preparation prevents piss poor performance. You see what I'm saying? So if you would have been prepping him, I mean, what was that, a year ago? This case been pending for a year? You could have times. You could have prepped him every Monday. You see what I'm saying? I mean, and another thing, it's no excuse for it, man, because I've had my client, when we won the murder trial, he was inside. He was in custody. Carmelo was out. I mean, y'all can have Sunday dinner by the pool and go over your questions. You see what I'm saying? So it's just no excuse for it, man. And like I say, I'm not the attorney police. I'm not the ineffective assistance of counsel police. That's similar to snitching to me. You know what I'm saying? Like, so I kind of do this, but I'm just telling you what I would have did. You know, I got a reputation of, we 17 and one of murder cases, baby. I don't really talk to the other side. You know what I'm saying? But I'm just telling you what I would have done if it were me.
Yeah.
But I'm sorry, let me say this. If ineffective assistance of counsel is the only way to get that man home, though, do it. I'm for it. If that's the only way, let's do it. Because that boy needs to come home.
That's right. How much impact do you think that newly released footage of the incident had on the jury if the jury would have been able to watch that video footage over and over and over again at home?
You saying like it's a bad thing that they could watch that outside of court? Is that what you're saying?
I'm not saying it's bad or it's good. I'm just asking you, I'm asking you, what do you think about it, though? What are your thoughts?
I think it confuses things, man. What I think was wrong and what I think the defense should have tried to find a way to do, because what I heard happen, you can't really see the figures on the video all the way. You can see the scrapping, you can see the commotion, you can see the movement, which is all vital to his defense, right? But I'm hearing that they let somebody get up there and explain who is who. I'm against that. I'm against that because there's so many factors.
They can't. They wouldn't be able to do that. If I was there myself, I couldn't have told you where I was because it's too grainy, it's too blurred. Everything is black. All of the people and their bodies are black, so you can't see what's what. Unless I had a full puffed out afro, and I'd say, well, that's got to be me right there, because the big puffed out afro.
Right, and you got to understand, in these cases I do, man. I mean, there's maybe on average 400 pieces of evidence. I delve deeply into each piece, man. So that one piece of evidence, that's some confusing stuff that they're doing over there to me. But why are you releasing it now, first of all? You see what I'm saying? Didn't they release it on Juneteenth or something? Something crazy like that?
I think they did. I think they did on Juneteenth.
Yeah, but I mean, I think it's just confusing because you have to look at all the evidence together. So you got to understand, people are just looking, there's many ways to a win. People are just looking if it was self-defense or not. Well, no, you need to be able to look at all the evidence and see, because what's for certain in this case is the time didn't match the crime. The time didn't match the act. You see what I'm saying? Now, a lot of circumstances surround it because he didn't testify. You see what I'm saying? So the jury can't say they knew what he was thinking. But, all of the evidence in its totality is important because not only are you trying to get somebody off, get them not guilty, you're also trying to get them. You see what I'm saying? So it could be something on the video that they could have used, to mitigate some evidence. But I heard them, that's another thing I heard wasn't much of an effort on the mitigating evidence in the punishment phase, which is a big problem, man. That's a big deal. It's a big deal.
Let's talk about the knife. Several people have argued that the knife should have changed because the knife was a multi-tool knife and not just a regular knife, that should have changed the way that the verdict came back. Legally speaking, what are your thoughts on that fact?
I don't, legally speaking, I'm glad you prefaced the question with that because a lot of people ain't gonna be happy with my answer. I don't think that matters. If it was a pencil and it was used to kill, it would be, you see what I'm saying? It would qualify as a murder weapon. If it was a highlighter and it was used to kill, you got a deadly weapon finding where the jury gets to decide if the weapon was used in a manner to cause, death. And, no matter what it is, I mean, if it got the blood of, Austin Metcalf on it, it's the murder weapon.
So Texas law, you're saying that shouldn't change anything?
Well, what I'm saying is I think that was a collateral issue. I don't think there's anything that swayed, that gave the jury the ability to check the not guilty box. I think that's a collateral issue the state used to kind of make the jury madder at him. Oh, he has a knife on the school campus. That's what DAs do. They play on their emotions. So even though, his self-defense claim has nothing to do with if he should have added the knife in the first place, that don't really matter. The self-defense is if he thought that he was about to experience serious bodily injury or death. You see what I'm saying? And he used, deadly force to defend himself. It don't matter if he should have had the knife or shouldn't have. That's just some extra stuff they threw in there to make them white folks mad. And I'm telling you, in Collin County, what the DA gonna do, it never fails. He came to your community. He's doing this where your kids are going to school. Your kids are supposed to be safe. They playing that whole card. So even though that's not in the black letter of the law, that is a method they use to try to get the jury on their side and to dislike the defendant.
Yeah.
See? Yeah.
But I can understand why they would do that. I mean, everybody trying to win, right? So I can understand.
You're right.
To be honest, if I was on that side, I'd do the same thing. My thing is to discredit the other side as much as I can. So I absolutely understand that. But if you were preparing Carmelo Anthony's appeal today, what would be the main issue that you would bring up to try to get that appeal granted?
Well, let's be very clear. I'm not an appeals attorney, but I do know how appeals work. And right now, I think this would be the part where we're getting the investigation done. We might be trying to track the jurors down and interview them. We would definitely be looking at I know that they're looking at the record right now. Again, error has to be preserved by the trial attorney, meaning he has to object in order for those issues to be appealable. They're probably looking at that stuff. The main thing that I've seen and had different conversations with people, in the attorney community is the jury charge. The judge put some language in there that wasn't the law, that spoke about provocation, that basically made it seem like, I can't say what the exact language is, but attorneys that see this will know exactly what I'm talking about, and probably everybody else. But it was a paragraph that says something like, almost was turning Carmelo into the aggressor. Like, if you believe that he was the aggressor in this case, blah, blah, blah. And that's, the jury charge is it's a packet, and it has all the law that the jury is supposed to depend on in it. The judge reads it to them before they deliberate. It's a very big deal. So my point is, if it ain't in the jury charge, you can't depend on it. And if it is in the jury charge, it has to be law. It has to be good law. So if you put bad law in the jury charge and the jury use that to render their verdict, sounds like an appealable issue.
Yeah, and don't the jury rely heavily on instructions from the judge? So if the judge say, hey, you need to be thinking this way, I need y'all, and look, y'all need to come up with a decision right now, today. That would be overstepping his boundaries. But I've heard of judges being able to do stuff like that. And doesn't the jury rely heavily on the instructions from the judge?
Are you talking about when the judge was like, I'm gonna put y'all in a hotel tonight if y'all don't have a verdict? I think that was improper, man. I think that was improper because you are basically rushing them to a decision. It might be a jury here that's ready to go home. It might be a jury here that want to go home to his babies tonight. He ain't trying to go to no hotel. Damn what the judge is talking about. I ain't trying to do that, judge. So I'm finna go and check this box right here. I was strong on not guilty, but it's cool, y'all. Let's go ahead and do guilty and get up. See, those are the kind of things that entice a jury to go outside the bounds of what their duty is. That's why you don't say that. You say to them, hey, y'all get this done as quickly as possible. Any questions y'all have, y'all send back to the bench, and we'll get both sides in here and we'll go over them. But telling them what you're gonna do if they don't render a decision quick enough, how can you not think that didn't affect their decision? I mean, that's they're supposed to feel like they got all day. They got forever in a day to as long as it's the correct verdict and they render it the right way. They're not supposed to feel like it's a shot clock. When the shot clock on 5, you look to shoot the ball. That's as simple as that, So
yeah, and it could be also a situation where a juror may think that if he doesn't follow the directions of the judge, that somehow he might find himself in hot water with the courts. So there's a lot of jurors who show up for jury duty. They're not really acclimated to jury duty. They don't really know how the process goes. And so they're counting on the prosecution and they're counting on the judge, who, by the way, gets this check from the same people.
By the way.
To give them proper instructions legally. You know what I'm saying? You heard the 911 call. I think we get the echo.
Yeah, I heard it.
Okay, so you heard the 911 call. Was there anything in that 911 call that could have been helpful or hurtful to either side that wasn't emphasized during the trial?
Not really to me, because you don't hear him say who's around him. You see what I'm saying? When I listen to a 911 call, I'm trying to see who's all in the room, because I want to subpoena them as a witness. I'm trying to see, how many, who else called the police, who was out there, who saw, who heard, whatever. On the 911 call, he's pretty much just hysterical, and he's saying that the guy's bleeding, and I think he describes Mr. Anthony as standing on the field or something. But he don't really say anything like, hey, Chris, pass me that ice, or hey, Chris, hold his legs up. It's nothing really that you could grab off of there to use to, turn it into something helpful to me. Now I do hope that and I wrote the guy's name down, I ain't gonna say it, but he says his name on the recording. And, I do hope they cross-examined him and called him as a witness, because it seemed like they didn't have much to play with, so I hope that that's something they sunk their teeth into. I wasn't there though, but I hope they did.
Yeah. What do you think about the public reaction to all of this, man? Do you think that social media has made things more clear in terms of viewing the evidence for the public? Or do you think that it actually has made objective analysis more difficult?
I think people's concern and their question of his attorney in this entire situation are legitimate. I think the questions are legitimate. I think that there's no way for somebody like me that went to law school to see this go on and not have questions. I think the Frisco Police Department kind of did some weird stuff too by letting people go down and watch the video. I don't really trust that. I'm not a conspiracy theorist, but you got to understand, me being a defense attorney, the prosecutor is required by law to give me everything, right? So there's a very controlled environment where that happens, right? And I get everything. So I can figure out if it's something you ain't give me. You see what I'm saying? But how they know that's the full video? Who's regulating when the video starts, when the video, you know what I'm saying? And I've never had a murder case where people in the public were allowed, and they were broadcasting that they were allowed to go down and watch the tape. It's almost like they were trying to taint the jury pool under the radar. You see what I'm saying? If it's I don't know numbers, if it's 2 million people in Collin County and 200,000 of them seen the video, I mean, that's, you see what I'm saying? I know 200,000 people didn't see the video, but I'm just saying, you don't know who's going to be called down to be on your jury. And you letting random people just come see the evidence. Jury not supposed to even see the evidence until the case starts. They're not supposed to feel no kind of way about the evidence. They're not allowed to read anything online about the trial, during the trial. They're not allowed to go home and talk to their husband about it. They're not, none of that until you start deliberating. That's when. You see what I'm saying? So, that was just very weird of them. And it's almost like this fake transparency, right? Think about this, Willie. You letting random people come watch the video at the police station, but the judge ain't letting no black reporters in. Are you transparent or are you not transparent? You see what I'm saying? Do it's kind of like they hiding the ball somewhere. Like, why would you be this transparent over here with the evidence, but don't nobody except people that was in the courtroom know what's going on in the courtroom? You see what I'm saying? It's kind of like a fake. It's like a pump fake. I don't trust it. So you ask, how do I feel about people's response, the public's response? And what I'm saying is, I think there were a lot of things done to kind of confuse the public and to make them choose a side. I mean, how people going to see the same video and some people saying it was punches, it wasn't no punches. Now we're not arguing if it was self-defense. We arguing if he was even under the umbrella, if he was even under the umbrella at the time. Now we arguing if it was, it's just it was too much going on, man. And I think that, we should have been a lot more quiet about our approach. That's how I would have been as an attorney. I wouldn't have done no press conferences. I wouldn't have threw the race card out there. I wouldn't have done, them folk wouldn't have knew what I was doing until I hit them with it. Until I had my suit and my briefcase. They wouldn't have knew what I was doing. Do I think race plays a role in this? I kind of do. But that's something that you kind of, that's something you keep in your back pocket until it's time to pull it out. You feel me? You don't leave with that and let these white folks know for a year what your angle is. You see what I'm saying? That's something I would have kept in my back pocket. And out of these 21 witnesses, all the pieces of evidence that come in, that's when you bring it out. That way they ain't ready for it. They got to think on their feet. You see what I'm saying? I'm gonna think on my feet. See, if you can't think on your feet, you're not a good attorney. You're not a good trial attorney. So all that letting them know what the play was and being in the media, I just think that kind of hurt. But that's the past, though. That's the past. I don't mean to be negative. I don't want our people to think that I'm, that's the past. But as far as how the public responded, I think a lot of things were done to make us look this way. Now everybody focused on race, and it's so much race conversation that members ain't even prepared for the case. I mean, how the defendant not ready? And I don't even think that falls on Mr. Anthony. I think that falls on the attorney. I don't just lean over and whisper in my client's ear, hey, you ready to go next? You testify next. And put it on him. I don't do that. I done had, 17 and 1. I ain't never did that. In 12 years, you prepared him. You do psychodrama. You ask him questions for you to get to know him. You ask him questions for him to get to know himself. You talk about why he thinks the way he thinks. Then after you do all the preliminaries, then you have him tell you the story over and over and over again until he's so comfortable with it, he can say it in his sleep. Then it don't matter what the DA done did in trial. Because see, my defendants, they be like this, Willie. Is it my turn yet? Okay. They be ready. Yeah. they be ready. You know what I'm saying? There don't be no, 10 minutes. Oh, this is my time. And we prepared for this. So, but yeah, very unfortunate. But I think he got a good shot, man, with the team he has, man. Yeah, a whole lot of faith in them boys, man. Russell and Justin, man, and them other attorneys, excuse me. Whole lot of faith.
Yeah. It was reported that the father, Jeff Metcalf, had a barbecue and he invited the witnesses to his house. And it was also reported that he offered bribes to the witnesses to make sure that they testified in a way that was consistent with the outcome that he wanted. If that is true, that is definitely grounds for a retrial, right?
If that is true, that needs to be investigated to the fullest extent. I don't know if it gets him an automatic new trial, but I know it gets him something.
Wouldn't that be criminal of him to do something like that also?
Yeah, that's witness tampering for sure. But him getting charged with witness tampering because of it and Carmelo getting an entire new trial, I think that probably is in a realm of possibility, but that's a long road. Appeal is a long road, period. But I think maybe going at the improper things that were done by the judge, that can be backed up with some law. See, an appeal, you want to throw the kitchen sink at him. You want to throw everything at him. You probably throw your strongest argument first, and then, everything else fall by the wayside. But you need law to support it. So you want to, all you need to do is prove one issue. You see what I'm saying? So if you throw 15 issues at him and you only prove one, if it's irreversible error, you'll win. But like I say, an appeal is a long process. He has a good team of attorneys that will do, all the legwork and all the legal work that needs to be done in order to do the process right and see that he's treated fairly. But, people need to know, 90% of appeals get denied. You see what I'm saying? So this ain't really something we want to rush on. This is something we want to make sure we get right. And the attorneys that he has, I think they'll get it right. I think they'll be very meticulous and they'll make sure that every box is checked and every stone is overturned for sure. Yeah.
Hey, if this had happened 10 years ago, do you think that the public's response would have been the same, considering that people wasn't as active on social media?
I think it probably would have been the same. You know, Black community been through a lot, man. We've been through a lot during the social media era, man. You know, unarmed people getting killed by the popo, and I mean, we got a lot of reasons to feel the way we feel, to the multitude that we feel it. You know, I think it would have been the same 10 years ago. You know, and I ain't mad at us neither. You know, who gonna look after us but us? But we want to make sure that we know what the law says. We want to make sure that we know what the facts were, and then we want to move, in the best way we can to help that boy out.
Yeah.
You know, but yeah, I think probably would have been the same. And you think it would have been different?
No, I think it would have been the same because we didn't have social media, but we got the news, which mainstream news, you can't really trust mainstream news, but mainstream news is such media hogs that they will put any story out, and anybody that want to talk, they got to keep on putting information out. They just going to feed the beast. And so some is going to be, they're going to show both sides. They're going to show the protest, and they're going to show the supporters. They're going to show both sides because that makes for good media for them, and it does well for them in regards to the numbers.
Yeah, I agree, man. I agree. I mean, social media might have been a little bit more wild 10 years ago, honestly. So, yeah.
Well, I think that I think Carmelo is going to fall into that 10% where he gets that new trial. Oftentimes, you can argue law when it comes to appeals. You can argue law, and you may have a great point, but you may not get that appeal because hey, nobody's really paying attention to the case and nobody cares. But the world eyes is on this case, and so they got to now dot those I's and cross those T's. Little old Collin County thought they were going to be able to hang this boy and bury the case, and nobody would care. And little did they know, that's why I believe that they did not allow cameras into the courtroom. I think they were trying to quietly make this thing go down. We're going to do what we want to do. We're going to hang him high. I'm going to give him a 35-year sentence, and ain't nothing nobody going to be able to do about it. This is what I don't understand. So you got a range of punishment from 5 to 99 years, right?
Right.
That was his range of punishment, 5 to 99.
Right.
And so I was always under the impression that the low end was for those people in society who may be more redeemable, who probably made a huge mistake, but it wasn't malicious. It wasn't a calculated malicious event. And so if you look at Carmelo Anthony's, if you look at what happened, he didn't instigate the incident. He didn't initiate anything. He was sitting down minding his own business, and he was accosted by a bully. Now, okay, so he stabs the guy. You can believe whatever you want to believe about how he to stab him.
Right.
Stabs him and the guy dies.
Right.
It was meditated. It was not planned. It's something that happened. You have people who commit crimes of passion, kill their spouse after catching them with somebody else, catching them cheating, and get 10 years in prison. I'm talking about grown people who are in their 30s and 40s, whose minds are as matured as they should be by that time, and they get 10 years. But you give this child 35 years who otherwise is an exemplary citizen. He doesn't get it. He is a model kid at home. He's not a troublemaker. People like him. Mm-hmm. And on top of that, the bonus is that he actually saved somebody's life before. If he don't qualify for the low end, I think he's 100% innocent, but let's just say he's guilty, and let's give him that. He's guilty. If he don't qualify for the 5 years, who in the hell does?
Exactly. Look, I mean, that's one of the things that they may have a play on ineffective assistance of counsel. What did you say? Most of the time, the lower numbers for the people who are redeemable, right? Who are exemplary citizens, right? That's what mitigating evidence does in a punishment phase. All he had to do, look, I reached out to the mom of the person whose life Carmelo saved. I reached out to the mom, and I had one question. I just had one question. I wanted to know, was she subpoenaed? She said no. I would have been there.
Wow.
I mean, she said no. I would have been there. You got to understand, to not even have her on ice, you're supposed to have her in the waiting room or sitting down by the vending machines with a Coke and some chips, waiting on you to send her the text. You see what I'm saying? You're supposed to have her in the building. You got to understand, that's why not calling him is so futile and it's so egregious. You didn't call him in the guilt and innocence phase. Okay, I don't understand that either, but that's the guilt and innocence phase. Once the verdict came down, now all you guys are focused on is getting him the least amount of time possible. Willie, I promise you, anywhere between 10 to 15 times during that trial, the prosecutor said the words indifference in human life, doesn't care about life. The entire time they were saying statements to make him seem like he is a person that has no regard for human life. Okay. It ain't nothing that rebuts that more than putting him up there for him to say, I actually saved a life. I mean, I actually risked my life to save a life. You see what I'm saying? They could have had something for them to look at. They could have had the newspaper article, entered that into evidence, or had the judge take judicial notice of it, publish it to the jury. And while I got Carmelo on the stand telling them about the decision he made to make sure somebody else, continued to breathe, I got the jury looking at the evidence, looking at the paper, passing it to the next jury. looking at the paper, reading the article. You see, so they can see that this man, quite frankly, he does have a regard for human life. And he doesn't have a reckless disregard for human. I mean, so to not even put your bid in on that, to not even call, I mean, it's one thing not to call her, to not even subpoena her, says she wasn't part of your preparation. It says she just wasn't on the list. I mean, it might be 50 different witnesses, and I put a dash and I put their role in the case. You see what I'm saying? And if he knew that was her role, that she felt good enough to not only go on social media, but to get in a newspaper article and give him praise for saving her son's life, she wouldn't have no problem doing that on the stand. He called Carmelo's mom. Okay, that ain't no fault to Carmelo's mom. I'm sure she did the best she could up there. Another thing, you said that it was heat of passion or whatever. Okay, people don't know. Once a guilty verdict for a murder comes out, you get a second bite at the apple to get sudden passion, right? So he could have put Carmelo up there. They could have did away with the self-defense stuff. No more talking about self-defense. But he could have put him up there in the punishment phase and had him say that he did that because he was so angry that the Metcalf boy tried to punk him, or that the guy, something. He could have got up there and explained to them why it wasn't premeditated and it was just something he did that was based on heat of passion. They didn't even do that. So, I mean, it's just, I don't know, man. I'm with you. Somebody diving in a pool to save somebody else, man, that's a certain type of person. You see what I'm saying? And the jury deserved to know that. And Carmelo deserved better than that. He deserved for the jury to know that not, I ain't saying it equals out, but it certainly takes away from the prosecution's claim that I don't care about life, which could have took that 35 down to 15, or could have took the 35 down to 5, So, and honestly, another thing about sudden passion, if the jury feels that it was sudden passion, it takes you back to 2. I think it takes you back to 2 to 10. I think it takes you back to 2 to 10. And they wouldn't have been able to give him more than 10. I'm almost positive it does. But it's just the point I'm making to you. You see all the avenues I'm explaining to you. It's just too many different roads to get them the result that they sought, and for no road to be taken at all, man. It's just like I say, the people's concern is legitimate, man. It's legitimate.
So I've been hearing a lot of chatter in the background where people are saying things like his parents, Carmelo's parents, did not sit in on the hearing of the sentencing phase when they actually sentenced him. When the judge gave him his time, his parents were not there. Can you explain to the slowpokes out there why a loving mother and father may not sit in on listening to a judge give their child who was found guilty time?
It's probably broken, man. I mean, it's a mom. It's a mom losing a son. I've had plenty of moms that, after we get the verdict, the not guilty verdict on the murder, right? Well, once we get and say there's a guilty verdict on the manslaughter, the lesser included. Well, mama probably sitting in the hall for that. She's relieved. She's relieved that you didn't get convicted of murder, but it's just too much for him sometimes, man. I mean, those are his parents, man. I've had conversations with the father. I haven't had a conversation with the mom. I assumed it was because she was a little more hands off because she was, going through emotions and dealing with how this is emotionally affecting her. But that ain't nothing. Like, these are things that are talked about months before, man. When I get to the punishment phase, often. I'm not bragging about that. I'm bragging in the Lord. Good Lord, done bless me to have the skills to pay the bills. And most of the time, we get a not guilty. Hence, not guilty boys. You understand what I'm saying? But in the event that they do come back guilty, we're going to have to go through a punishment phase. And I say, give me a list of people that can say something good about you. Give me a pastor that can say something good about you. Pick your favorite teacher of all time and give me her information. And we prepare for that. You see what I'm saying? So my point to you is I'm sure the attorney was probably aware that mom ain't want to sit in there and listen to that. I mean, she's probably outside trying to keep it together, man. And my heart goes out to that family, man. I mean, I can't imagine what losing a child is like, So, I mean, that didn't play that much into anything for me. I tell the mama, I say, mama, do whatever makes you comfortable. I'm going to go here and handle business. I'll come out here and tell you what the verdict was, So, I think we got to be sensitive to that, man. But, I can't imagine how hard it is having to emotionally keep it together and still get this work done. Because you got to understand, an appeal, I mean, it ain't forever. They only got a certain amount of time to hire an attorney, get the investigation done. And so I'm sure they're juggling a lot, man. You know what I'm saying? But, it's hard to know what they're thinking, though. It's hard to know what they're thinking. I'm sure it's traumatic, though.
As a trial attorney, how hard is it for you to emotionally keep it together and still get the work done? Because, you're often not like, you have to deal with families' grief. And, when they call you oftentimes, you're dealing with people when they're going through one of the roughest patches of their life. You being a passionate guy who does the work that you do with your partner, what type of cases take out of you?
Man, I got to be humble in the Lord and say it don't take much out of me at all, man. And I'm laughing because I've been asked that before and people don't believe it. But I haven't worked since May 16th, 2014, man. This is what I was put on this world to do. I was put here to be a conduit of the Lord's grace and mercy, man. Everybody got a job to do. I mean, the good books say that, Christ is the head of all government. You know what I'm saying? So my point is, I think he cool with what I do. I mean, he the head of government. Everybody got a job to do. I mean, if you're a prosecutor and you are just as passionate about putting people in jail as I am about keeping people out of jail, I ain't mad at you because I can relate to your passion. Now, I'm going to beat you. I need to beat you. I'm going to put pressure on myself to beat you because I don't want you to win. I don't want you to gain your objective and put another black man in jail. You understand what I'm saying? So it don't take nothing out of me, man, because I'm very passionate about it. And the way I got into this because I got in a lot of trouble growing up and I didn't have a lawyer for me. So I'm very knee deep in my purpose, man. So, you know, I think it just comes with the game. If you got to explain to mama what happens to her baby if this goes wrong, then that's my responsibility. But I don't think that I try not to pay any attention to the emotional side. The DA is going to do that enough. You know, I got to make sure that I'm sharp. I got to make sure that I'm thinking on my feet, and I got to make sure that I know what the DA's next move is. So it ain't really much time to be sad and going through it. Now, I have been in some trials where the pictures, you know, maybe a baby passed or something, and the pictures kind of mess you up, and, you know, if you got kids. But anything other than that, man, I mean, I'm sure other attorneys do, but nah, me and Mike, man, this kind of what we was put here to do, man. So you can have a lot of confidence when you know you got the lawyer behind you, you know. Yeah,
and I wanted to show everybody your YouTube channel. This is Not Guilty Boys, right?
Yes, sir.
Yeah, Not Guilty Boys. This is the YouTube channel. Y'all go follow this channel, fam. You're gonna learn a whole lot. Go follow the channel right now. Everybody, I'm gonna give y'all a moment to go follow this channel.
Shout out to Michael Campbell too, man. The other half of Not Guilty Boys, man.
That's right.
They're stepping.
Come on now. Speak on it, fam. We had 589 subscribers at the very least, man. I know we got at least 3,000 people listening. We supposed to be over 3,000 at least subscribers before we get off this line. At least.
We 17 and 1 in murder trials, man. We just trying to get the people something to sink their teeth into, man. Let y'all guys know what the law is. Let y'all know what to do when you come to the sea. Find out more about the law and how to apply it, man.
Yeah, that's what's up. That's what's up.
Give us a call if you need us. I appreciate you having me on the show, man. I really do, and I'd love to be here again, honestly.
Absolutely, man. I got you, man. And I appreciate you coming on the show and imparting your wisdom.
For sure.
Ladies and gentlemen, Andrew Wilkerson, attorney Andrew.
Yes, sir.
Let me put some respect on his name. That's what's up. No more talk.